This is Elizabeth Townsend. This is for Dean Massaro's Preparing for Lives in the Law Project, and this is an interview with Professor Dan Dobbs. We're going to start out with the first beginning easy question. Why did you go to law school, and was it what you expected when you got there?
Why I went to law school was I couldn't think of anything else to do. And I was about to get married. I did get married before I went to law school, and I decided I had to settle down and stop being an undergraduate, do something to make a living. And I wasn't expecting to care much about it. And I did. It was totally different from anything that I could have imagined. It was you know, this is who goes into teaching, I guess, is people who say, God, I really like this stuff. And I did. You know, it was the first time in my life anybody had ever in class said, well, what is your opinion about this, Mr. Dobbs? You want my opinion? Gosh, they want my opinion. And instead of, you know, and I know a lot of students don't like that. And, you know, they feel afraid or they feel they'll get it wrong or something. But I was so naive, I just thought, God, they want my opinion. So I loved it. And I always had one. As Dean Livermore said, you know, you always seem to have a lot of opinions. He's a sweet man.
And for people, we've asked this of a lot of Professor Ayers now. Did you have a perfect law? Were you perfect? Did you have perfect grades, and did everything come easy to you in law school, or?
No, I didn't have perfect. I had some grades I would be ashamed to admit to. You know, I don't even want to talk about it. But no, I didn't. But it was because it was my own fault. I was upset with a teacher who was a great disappointment to me. It's kind of a funny story. You want to hear it? I was in school in the early 1950s, and he had been teaching this real property course for many, many years. He was using a book that was 3 editions old. He was still using a book from the 20s that he had gotten some work study student in the 30s to brief all the cases in. And so he didn't ever read these things. These are all briefs that the student made. The only thing that we knew that he didn't know was the student never briefed the cases either. He just got what used to be called Chicago Outline Series, just canned briefs. And he typed them up and gave them to the professor, and the professor thinks he's reading the student's briefs. We know that the professor's a total fraud. And I was just so upset. I really just couldn't give that class anything. So things like that happened, and but otherwise I thought I had a very good legal education. This was an exception, including one of my favorite teachers my first year was Ray J. Davis, who later came and taught here at Arizona, and was here when I moved here. He was teaching torts by that time, so he and I were both teaching torts together, although he'd been my contracts teacher in my law school. I'm rambling on. You ask another question.
No, this is good. This is what you're supposed to do. It's about rambling.
I'm supposed to ramble?
Oh, and it's also going to be all edited, so it doesn't make a difference if you decide you don't want to talk about something, or it's really casual. Like this, right? Okay. Did you like torts from the very beginning? Was it something?
Yeah, I did like torts. I really did. My father and grandfather were both lawyers, and my grandfather died when I was 4, but my father was practicing law, and he and his firm did tort work. Maybe half of their work was tort work. So it was what I thought law school was really about, and it was for me, and it was wonderful.
And what did you do after law school?
I went with my father, and by that time his partners had all died, and one of his partner's sons was my age. I'd grown up with him. And he and I graduated from law school at the same time, and we both went into practice with my father.
And did you know that you wanted to go into teaching from the very beginning?
I kind of always thought it would be fun, but I had no plans to do it. I just planned to practice law with my father, which was fine. I loved it. I didn't leave because I didn't like it. But I did always kind of want to try teaching. And my old law school asked me a couple of times to come teach a course, and I was too busy and I couldn't do it. And when I thought I finally could go teach a course for a semester. They didn't need anybody, and they said, well, why did the dean say, why don't you go into full-time teaching? And I kind of scratched my head about that, and finally decided I would give it a shot, which in my case I thought I had to get an advanced degree, because my school was certainly not a famous school. It was the University of Arkansas, which was, I think I got a good education there, with the exception of Judge Pudge, as we call him, with his canned briefs. It was, I felt like if I was going to get into teaching, I had to have an advanced degree. So I went to the University of Illinois then and took a couple of degrees and went into teaching.
What kind of degrees did you get at the University of Illinois?
Master of Laws and a Doctor of Laws, SJD.
And you focused on torts when did you know that you were doing, or
No, we didn't focus on anything. I spent most of my time writing dissertation. They had a wonderful library, which was totally new to me. They had lots of old English books that were hundreds and hundreds of years old, which now that doesn't seem like so old that I'm approaching that myself. But it's great when you can look at a book it's 400 years old, and it's some lawyer who's writing in the 1500s, and gosh, he's writing about stuff you understand you understand this is a problem, and you understand why he's writing about it, and it's different language to be sure, but it was great. So that's mostly what I was doing. We had to take courses, but my real life was involved with those ancient books.
All right, I'm going to ask a muddled question that kind of relates. There's a whole thing about whether people should have advanced degrees, like a JD, PhD, or the SJD, or if they should practice. And you had some practice experience and the SJD. Do you have any thoughts about sort of
as a prerequisite to teaching?
Yeah,
you mean?
Exactly.
Well, yeah, I guess I do. I would like to see people have practice experience. Not a lot, maybe. I don't think that is the most, but I sort of feel like if you're going to teach people who are going into practice, and even though all of our students don't, many of them do, and those who don't go into practice still come to law school to get legal skills. So I sort of feel like, we ought to have that touch with practice, and I know there are some wonderful, wonderful teachers who have never practiced. So I don't know what kind of rule I would make if I were the rule maker, it impresses me when I see candidates who practice law a little. On the other hand, I kind of worry about people who practice law 20 years. I kind of think, no, I'm not sure about this.
Because they won't be in a sort of scholarly frame of
mind. I think that's not something that it's an adjustment to move from practice to teaching, even if you haven't practiced very long. So I think there's a risk that maybe you practice too long, but that's, generalizations are, what are they worth? You have to judge individuals.
What about the notion of advanced degrees for people who want to teach? Do you think you always hear people talk about clerkships, but you don't hear much about.
I don't think advanced degrees count for very much. I think as a practical matter, the person who wants to teach has a problem of, it's just like baseball bat and the mule. What do you use the baseball bat? That's to get the mule's attention. You got to get somebody's attention with something in your resume when you're dealing with thousands of other people who want that job. And that's unfortunately the way things are. Well, maybe it's not unfortunate. It's unfortunate for the person who wants the job. So I think if you haven't got anything else, maybe an advanced degree is worth something, but I'm not very keen on it. I'm not that keen on clerking. I clerked in the middle of my practice. I clerked for a U.S. district judge. As a favor to him, his clerk left in the middle of a term, and I practiced law in his court, and he asked me to come help him out, and then he kept postponing, and so it stretched out over months. But I enjoyed the experience, but I have real qualms about telling people they really need to go clerk if what they want to do is practice law, because if they've got a job, the sooner they get to that job, the better. Clerking from a lawyer's point of view may be good business to say we have a clerk, or maybe the clerk gets to know judges and how they work better, and that's good. But I don't know whether it's a good career move.
Why do you think it's touted so much? Why it's become such a big deal?
I don't know. I think it is important for some. It's a good thing for some people. I'm not against it. If you're going to go into teaching, you need something, and clerking, if you could clerk for the Chief Justice, no matter who he is or whether he's destroyed the Republic or not, you can do something with that.
It's your bat.
You can say it's your bat for the mule. You're going to get the mule's attention if you clerk for the Chief Justice or anybody on the Supreme Court. And you're probably going to get their attention if you clerked on a U.S. Court of Appeals. It's not so clear you're going to get their attention if you clerk for a lot of district judges. You clerk for a state court judge. It's not particularly famous. So I'm not sure whether it's a payoff for everybody. From the school's point of view, the school is glad to do that because it's good publicity for the school. But I don't regard that as a very high motive myself. I don't think the school should be trying to use its students to get publicity for itself.
All right, so I want to ask you a couple more questions on this topic, but a little bit different. We talked to a lot of practitioners about sort of what's the point of law school, what should you be doing at law school, and some of them are very that it's a neutral place where you learn the law, that is the thinking like a lawyer kind of stereotype stuff. Others say that you should come out knowing more practical skills. It's a very obvious question, but sort of where do you see things? What are we supposed to be doing when we're at law school? What are your thoughts about that?
I think people, lawyers, myself, you, all of us, forget how much we didn't know when we started. I think that what happens if you're successful, even reasonably successful in law school, is that you internalize a lot of information, a lot of ideas, and you don't know when you learned them. You think maybe you knew res ipsa loquitur when you were 4 years old. Well, maybe not literally, but you sort of feel like that's easy, and you can see that in a lot of cases when you talk to students who go clerk at the end of their first summer or even their second summer, and lawyers have expected things of them that they just don't know, and the lawyer honestly thinks, well, gosh, anybody knows that. But when I hear what it is that the lawyer expected him to know, I can guarantee you that lawyer didn't know it at the end of his first year or her first year either. So I think what it is that that's all been internalized so much. It's a part of your personality, it's a part of your intellectual equipment, that you don't realize that you learned it at a specific time and place. And that's one of the things you're doing in law school. You are learning a lot more than maybe you think when you're taking the exam and you can't remember something. But the stuff you have remembered, you do know, is just totally impressive. So I think that I kind of disagree with those lawyers who think that you don't really learn enough in law school. I think most students learn an enormous amount. I think most students could learn more, and I'd be happy to try to cudgel more into them.
Like what? What would you want them to learn?
Well, I think many students still aren't very good at reading cases with any sophistication by the time they graduate or in their third year. I don't want to say majority or anything like that, but there's always improvement that you can make, and I think reading cases is done at a very low level sometimes, and even Supreme Court judges. Last year I read an opinion in which it was very clear to me that the judges were reading law, I'm talking about the United States Supreme Court, or reading law as if it were embodied in formulaic words of an opinion rather than saying, well, when we look at what they do overall, it's nothing like what they're saying. So what do you mean by a rule? Do you mean what they say, the words they use, the formula, or do you mean what they're doing? And it pretty is as pretty does. Doing is what counts. But even the Supreme Court of the United States, I thought, within the last 2 years, was missing that, to me, rather elementary point. And it's a real easy point to miss for students, and I think they should do better with that. And I think, you know, it's our, if they don't, it's whose fault is it? It's ours. And this ought to be something that we're making clear to them, that there's something more than just reading the words. So that's an example. I mean, I could go on forever, I guess.
So if you could do anything you wanted, you could have law school any way you'd want. Is there something you would change to make that? Would you have something the third year where they would have a more advanced case, short class?
I would make my colleagues insist on that they read cases. I think some people just get away from case reading, and it's boring. I mean, you got to admit that it's, you know, it's not after the first excitement of exciting cases in torts. You have to go off and read contracts or real property. I'm just joking. you know this gets to be a bore, and I understand that. As a bore to me, I slog through cases every day. I'm on Westlaw every day, probably 7 days a week, and I read lots and lots of cases, and it's not the most fun thing in the world, but but doing it is important, and being challenged to do it well is important, I think.
All right. Speaking of torts and laughing about it, okay, we've interviewed a lot of people who do a lot of things that are kind of sad and depressing. That they deal, like lawyers who deal with lots of indigent clients, who all these things that could be considered depressing. I found your class overwhelmingly depressing because of the stories.
Thanks a lot, Elizabeth.
I just remember thinking, like, the stories were so sad. I mean, it was just like everything was fine, and then suddenly someone's blown up. But you know, all these things happen. I mean, it's a class of tragedy, and I wanted to know how you deal with that, and if you ever felt that way about it, and how it affects your life. I mean, do you see it affecting sort of how you interact with people? And because you see, I mean, everything's a potential just disaster. I mean, when you get into
I am very cautious about how I drive and what doctors I go to. That's certainly true. Well, I don't know if yes, it is sad and depressing to deal with someone who's seriously injured. I assume that's what you're talking about.
Right.
There's other torts where you're dealing with libel or slander or fraud or economic torts are a little bit different. But yeah, I think it's very hard to deal with that. But it would be hard to deal with it as a doctor as well. And I think that what doctors do and what lawyers do are very similar in that respect. They build a kind of professional barrier between them and all of the emotions, and at least as long as they're working on it. And that barrier may fall at night. There may be nightmares at night, but you know, at the time when you're actually working on it, your professionalism takes over. I mean, the doctor is stitching up the patient who's been broken into 100 pieces. There's no time for the doctor to break down, and there's no time for the lawyer to break down. So I think during the time when you're doing professional work, it's okay. At other times, I think maybe it's not. And to me, the worst cases are domestic relations cases by far. I'd a lot rather deal with tort cases myself than domestic relation cases, because those are ones where you have to wonder about the whole human capacity and the whole human spirit. And what you wonder about with the tort case is somebody went wrong for a tenth of a second and the car crashed. Or a doctor made an error of judgment. Maybe he did terrible things, but it doesn't reflect on him as a human being. But domestic relations, children, you may have to wonder about the whole human race. So, I think it maybe is a matter of your outlook. I know lots of domestic relations lawyers that wouldn't do anything else. And the upside is, I don't want to end on that note, because the upside is that if you are a dedicated professional, you feel like you're doing somebody some good. You're doing what you're supposed to be doing. Whatever they did, you're doing what's the right thing for you as the legal professional. You're helping somebody get appropriate alimony, or you're helping somebody get appropriate recovery, or you're defending someone who has been inappropriately charged, or who has been charged with too much. Maybe there's no inappropriate charges, but charged with too much. That's easy. So I think you feel good about that, and at least I did in practice. I felt better about it when my clients were individuals than when they were corporations. I mean, it's just not easy to feel like, oh, at the end of the day, I've saved the insurance company some more money. I mean, you do feel good if you do a good job, but it's a lot easier to feel good if what you did is you saved a human being his job. And that's where people live. So, yeah, but what isn't like that, It's good and bad sides to it.
Do you feel like, okay, I know you don't, do you feel like reading about it is different than practicing it, in the sense of sort of how connected you are to
Sure, of course it is. Would you rather have cancer or read about it? You'd rather read about it.
Right. Well, like when I was, I studied European history, and I couldn't deal with, after a time, it was the Holocaust stuff. I liked it, but it was your thing about, it was humanity breaking down.
That's really right. Yeah, it's just such a massive scale.
Yeah.
And you feel, and that's what you get, that's the sense you get. That's a good comparison, because although it's not really like that, that's the sense you get when you deal with the same kind of problem over and over and over again. And that's what happens with domestic relations. The husband who beats his wife over and over and over again, who bashes his child's head against the wall over and over and over again, who doesn't pay alimony over. It's you feel like everybody's bad, and it's not true. But it's how you feel when that's what you do professionally. My father used to say he would never practice domestic, and he didn't. He never practiced domestic relations law, because he felt like it did have such a bad effect on everybody. And of course, I was smarter than he was, so I said, I've got to practice domestic relations law. So I tried it a few times, and the first client I had had called me up 6 o'clock Sunday morning with black and blue in the hospital. I didn't think she'd survive. She'd been beaten up by her husband. I think this is going to be my last domestic relations case.
Okay, let's go through, if it's possible, a typical day. What is your typical day like? Do you have a typical day?
Now?
Mm-hmm.
I get up usually around 3. Sometimes I can sleep later, but it's not dedication. I wake up. I make coffee, stretch my old bones, and then sit down in front of the computer and get on Westlaw, or work on stuff I've downloaded, or work on class notes, or write whatever's next on the agenda. Prepare for class, teach class, come back home and do more of the same that I was doing at 3.
And when is there a certain time that you stop working, or do you feel like you just always are working? Is there a way,
Well, you mean like an hour? A certain hour of the day?
Well, sometimes people, I guess that's it. There's a sense of, like, some people there's just a sense of always working. Sometimes they say dinner time, or sort of.
I don't work at night. I don't ever work at night. I quit somewhere around 4 or 5 in the afternoon, and depends on how tired I am or how pressed I am, but usually by 5.
And do you think it's important to do other things besides the law, or do you think that the law can?
I'm not very happy with how much time it takes me to get my work done. There's certainly lots of other things in life, whatever interests people. But some of the things that I like, I can do, even though I work a fair number of hours. Music, you heard music when you came in. I like music, and that's something I can have on while I'm working. We go to, we take a vacation almost every year. I missed a couple. I was trying to finish that Torch book. But other than that, we've frequently gone to Europe and or elsewhere, and we like that a lot. I'm not as active in the community as I was when I practiced law. Hardly do anything. Well, I don't do anything. It's not hardly, I don't. So that part of my life is not as well balanced as it should be. I can't ever seem to learn enough law. That's my problem.
And how do you learn, I mean, how do you continue to learn more law? What is your, sort of, do you?
Well, everything leads to something else. You know, if you're practicing law, you can't afford that. That's a luxury you have in teaching. Well, for example, I've been working on. There's some cases, a lot of cases say, well, you can't sue a doctor for malpractice unless you have a doctor-patient relationship. Well, that sounds pretty good on the surface, and then it turns out, well, that means, to some judges, that means if a doctor examines you for, say, your employer finds that you have a cancer that needs immediate treatment, he doesn't have to tell you about that because he's not in a doctor-patient relationship with you. Whoa! Well, that makes you think a little bit, so you kind of want to know what other cases say. So you say, well, what are they saying here? And then you find, well, some of them say that, but then what they're doing is dealing with economic loss rather than the cancer. And then you say, well, what other kinds of cases use this doctor-patient relationship rationale? And you say, well, it turns out there are cases with doctors who are on call who didn't show up or refused to show up. No doctor-patient relationship. You can't sue me for not showing up when I was on call and save your life. So one thing leads to another, and you say, well, what other kinds of cases? And you keep on. It just never ends. And I read recent case. I read the Westlaw Bulletin twice a week. Check out all the cases. Pick out as many as seem to be important, and then I read the whole case. So. Yeah, you keep on, and there's so many surprises. You know, there's so many things.
And do you think that students thinking about practicing law, that they should be doing these things as a lawyer as well? Or is that a space for scholars to what should they
I
be doing?
don't think you can I don't think you can practice law and do quite what I do. I couldn't practice law and do what I do. I doubt if many people could. But I think they do have to keep up. That's probably something that we don't emphasize enough in law school. I try to mention it, but I don't think it sinks in the first year. I think you need some kind of professionalizing course toward the end where you say, let's talk about keeping up, or maybe not a course, but something. But yeah, I think lawyers have to. I was reading a legal malpractice case just before you came from New Jersey, where a lawyer brought suit for do you know the wrongful birth cases where a child is born with terrible chromosome damage and the mother sues and says, well, if the doctor had just told me that this was a risk, I could have had an abortion, I could have terminated the pregnancy, and legal abortion, legal termination, and none of this would have happened. Well, what they mostly say with respect to the child itself, though, is the child has no cause of action. Because what is he claiming? He's claiming he shouldn't have been born, and that just doesn't wash for most judges. But a few courts, including New Jersey, where this case was from, say yeah, the child does have a cause of action, although it's only for the extraordinary expenses that he'll have as an adult. After he reaches majority in chronological age, he'll still have these expenses. So this lawyer brought suit for the mother, but didn't bring suit for the child. What happened was, it was 3 months after the New Jersey Supreme Court had first recognized that wrongful life cause of action on behalf of the child. 3 months, only 3 months. How would that lawyer have known it if he wasn't reading every case as it came down? Not catching up a month later, not catching up on his beach vacation in the summer, but reading it as it came down. It's an overwhelming task, even just to do that. But if you're practicing in New Jersey or Arizona, you read those cases. You don't have to read the whole nation's cases. You need to keep up about what's going on elsewhere, but you don't have to read all those cases. You need to read something to help you keep up.
So if you're in Arizona, you're reading Arizona cases, would you also be reading Ninth Circuit cases or California?
Sure. Well, I guess it would depend on the kind of practice you're doing. If you're doing exclusively domestic, I don't know why, I don't care about domestic relations. I don't know why we're talking about this so much, but if you're doing exclusively domestic relations, you probably wouldn't bother with federal court stuff because federal courts don't deal with domestic relations. But if you're doing criminal law, certainly you'd read the criminal cases from the Ninth Circuit. Sure.
So it seems like trying to get a sense of, we have all these different people talking about the same system, and it seems like your role in the system is this sort of the knowledge. I mean, obviously, you're the sort of a knowledge base, and sort of I wanted to talk sort of more how when students leave, what they should be looking. I mean, they don't have the time to synthesize and think about the law the way you are. So is that what they should be looking at when they go to sort of treatises or law reviews?
Yeah, I think they should look. I think that I've been reluctant to talk about treatises because in my class, because since '85 I've been an author on a treatise, and I sort of feel like maybe I've done the wrong thing. I don't want to seem like I'm trying to sell my books or sell myself, but I do think we ought to tell students the first thing you should do is review the treatise, because so many cases, I read cases all the time, as maybe you're getting the picture here, and so many of them are cases where the lawyer just has not conceptualized the case well. I had a student call me last year, still a student. She was clerking. She sent me an email, I guess, and she said, "I'm sorry to bother you, but I just can't get a handle on this problem. What about such and such?" And I said, "Well, it shouldn't be a problem because I think there's cases that say such and such." She told me later that resolved the case as soon as they got onto the right set of cases. But the case before that, they had been dealing with this case for 3 years, doing this, that, and the other, depositions, this, that, and the other, when in fact there was authority that said there's no claim here. And so getting to the right material that's what it's all about. So yeah, I think they should start with treatises and read law review articles and not just cases, because you get a slant on things. I gave a talk last fall, kind of a CLE talk, and a torts teacher told me this, I'm going to have to look at your book again because I didn't have this slant on this whole topic. And I think we all have a different slant. So it's always good if you're looking for ways to sue or defend, it doesn't matter which side you're on, to try to see what's out there as a possible way of categorizing the case, characterizing the case, what kind of claims, what kind of defenses. And so often they're just not, you think this is the wrong one. And judges pick the wrong one, but they pick it because lawyers argue the wrong one. I mean, judges don't go out and do this stuff. They listen to what the lawyer says. So, yeah, absolutely.
So how maybe we could talk a little bit more about this notion of conceptualizing a case. How would you begin? I mean, I'm not talking about on like a research sort of like how do you begin your research, but in terms of sort of do you go to the treatise first and then sort of see or compare different treatises to see how it?
I think it's a dialectic process. I think you go back and forth. I think you go to the treatise, it gives you an idea. You go to cases. I mean, this is not all one thing. As you mean, the treatise, you read the case, the treatise cites, and you say, well, that isn't quite my case. And then you go back to the treatise, and then you say, well, maybe I could generalize my case. And I think that's one of the weak points in a lot of arguments is failure to get the right level of generalization that you need for your case. It's easy in practice of law, it's the easiest thing in the world to get bogged down in details, because that's what you have to think about. You have to think about details. You have to think about who's going to say what in trial and whether that will prove your case. So you're thinking a lot about details, and it's easy if you do that to miss the possibility that what you need to do here is to generalize the authority, to see this case as a little bit different. Let's see if I can give you some examples. Here's one real quick, still on medical malpractice. The doctor who examines, I mentioned the case, the doctor examines an employee for the employer's benefit, doesn't tell the employee about cancer. That's a medical malpractice case, or it's nothing. But what about the doctor who examines the employee for the employer and gives the employer a false statement of the employee's health? And the employer says, well, I got to fire you. I can't have such an unhealthy employee around. Now that's not a case you have to think about in terms of medical malpractice. You can think about libel or slander. You can think about interference with contract. So, you know, if you don't give yourself a chance to do what the old lawyers did, which is literally stay late, put your feet up on the desk, open that bottom drawer, pull out whatever bottle you have there, and think about the case. And I'm not arguing for alcoholism, but I think what I'm trying to do is give you a picture of the attitude you need to bring. You need to stop and think. And I think that particularly big firm lawyers that's just a big luxury for them.
And they don't, because of billable hours.
Billable hours, it's real hard to do, especially if you're low in the food chain. The whale's going to eat you if you're not careful. So you have to be sure you are bloated up with those billable hours. You're too big for the Leviathan. That's tough.
Do you think that young lawyers are afraid to take the time to do what they need? This takes
I don't
time.
think they think about doing it. I think that if you're in a busy practice, and it's not just big firms, but if big firms have some special problems, but if you're in a busy practice, you don't feel you have time. And it's like so many other instances of, stitch in time saves 9, and we keep multiplying. Well, if you've ever seen any big files, you see files, they grow like this, and they get bigger and bigger and bigger. And you know what? The stuff compressed to what is actual information is about like this. But what's happened is those files get bigger because the lawyer doesn't have time to write a short letter, to use Justice Holmes' phrase. I'm sorry I wrote a long letter, didn't have time to write a short one, didn't have time to summarize, didn't have time to get to the meat of it, didn't have time to think about it, so they included a bunch of stuff that you don't need, don't care about, never will care about. And of course, then when it comes time to read it, it takes more time to read it. So it's kind of self-defeating if you don't stop and think about things.
That makes sense.
So I think.
That makes sense.
But I have the advantage of not having to worry about making a living with clients that are badgering you and senior partners that are badgering you.
Professor, we interviewed Professor Malway last week, and obviously he comes from a very practical, and his book is all about, making it practical, and I wanted to see sort of the opposite. Do you see yourself as the opposite of that, or do you see yourself as a practical? I mean, I don't mean that in a bad way. I mean, that sounds like that. Let's start again.
No, I didn't think it was bad, but I don't see myself as the opposite of being practical.
Because you're such a...
Well, I have a different, Tom and I do have a different emphasis, but I doubt if either of us would really, Tom and I have talked about some of the problems in some of his teaching materials, and I doubt if either of us would see the other as off the mark. We have different emphasis, but they're both emphases that practicing lawyers have to think about, and I have no problem with that. I think the practicing lawyer better think about finding out what the law is and how he can think about his case for the defense or for the plaintiff, as well as think about just repeating somebody's set of words. Mm-hmm. But it's real tempting to do that latter, just repeat somebody else's words when you're getting a pinch for time.
It's really interesting as you say this. I just keep thinking back to all the interviews we've done and some of the people and this whole emphasis on practical, that they don't really I can see what you're saying about that they don't get that there's a lot of other stuff that's going on here as well. That practical is very important, but that if you don't get this learning, this sort of notion of thinking about things this way, you're not going to get it when you get out.
Yeah, I don't think you are, not easily anyway. But there is something else, and I say this for people who emphasize the practical, and I don't disagree with that, except maybe in a little degree. I think there are other things besides what I'm talking about in the practice law. I've been talking about litigating cases and formulating arguments, conceptualizing your case in a way that will win. Say, conceptualize it one way, you have a statute of limitations problem or a cause and fact problem. Conceptualize it another way, you beat both of those. So those are what could be more practical than winning, you know. So that's
Right.
practical, but that's not all there is to practicing law. And so sometimes what lawyers may mean by practical is not anything in the area I'm talking about, which is formulating arguments, conceptualizing cases. You have to, one aggravating problem is getting witnesses. Make sure your witnesses are at trial. If you go to trial, where are your witnesses? Somebody has to be getting them. Somebody has to make sure they get there, and preferably in a state of mind that's not angry with you. So you think about, well, you go drag a witness away from his job, drag a witness away from his farm, whatever it is. There's lots of things in life besides going to sit in the trial, and everybody but lawyers know that. So they don't want to go sit in the trial. You have to think about what do I do here. That's a practical thing. That's not a minor thing. That's not anything we should be teaching about in law school any more than we should be teaching speech skills. Those are real practical. If you're going to try a jury case, speech skill is very important. But it's not appropriate to law school, and neither is the psychology of pampering witnesses. But they're very practical things, and they are important in the practice, and they are likely to take up more time for lawyers than reading cases. And I'm not sure if that's a good allocation, but you have to finding experts. It may take you months to find an expert. You go find the right expert, and he says everything but one thing that you need, and one thing does you in. Now you got to start all over again. So practice law is exciting partly because it's not all one thing. It's the elephant with all those unsighted people feeling it. You remember that story? For one of them, it's like a wall. He's feeling the side. Another, it's like a rope. So it depends on what you're doing at the time is kind of what pops into your head, and you say, well, you got to be practical. And you're thinking, well, I just spent 3 months trying to find an expert witness. And that's true. You do have to be practical. You do have to find those witnesses. But I don't think that, none of it works in litigation. There's lots of law that isn't about litigation, but in litigation, you have to keep focused, I think, on the end. You have to be thinking about what happens if we go to trial. You don't want to think, well, we'll get this settled. You think, well, probably we'll get this settled, but the way to settle it for the best price, either for the defense or for the plaintiff, is to know what will happen if you go to trial as best you can. You got good witnesses, settlement value is higher. Bad witnesses, it's lower. That's just a fact. You better think about that. You better think about what kind of theory you have for your case, what kind of legal rules are going to be argued. I don't think lawyers are always practical when they think they are. I had a lawyer call me one time in another state and asked my advice about something. And I said, write this letter. And he said, well, what good will that do? We can't get it in evidence. I said, no, you can't get it in evidence. He was thinking about forward to the trial, right. But he wasn't thinking the next step. What happens if the other side tries to get it in, because they will if you write it the way I'm telling you to. And what's going to be in that letter is going to do them in as well as help them. And so you write it this way, and it'll be in. Bang, wins his case. It's easy, but you have to think about what's going to happen all the way down the line. It's like a chess game.
Now, how did you know that that was the case? Was that just out of experience that as you...
Oh, you know the rules of evidence, and you know what the incentives are. I mean, I can't tell you the facts of the case,
but
but
I'm just saying that...
the incentives
Right.
what you're doing is calculating the incentives for the other lawyer. It won't work if the other lawyer's too dumb to know what his incentives are. That's a horrible case. That's horrible. Nobody likes to practice with a dumb lawyer on the other side because it screws up all of your calculations. You know you can't deal with it. You can't say, yes, I can set him up this way to ambush you. It won't work because he just angelically misses the whole point.
Okay, I have a couple more questions. I don't want to run out of time. What do you see your relationship with lawyers, like what you do now?
Gosh, I love lawyers. I like lawyers a lot. I always like talking to them. I don't see enough of them. That's the sad thing for me. But I love talking to lawyers. And I don't want my relationship. It's like too much of the rest of my life is too much time spent on my computer. But sure, I like talking to lawyers.
So do you think that when people get out of school and they are lawyers, that they're supposed to use their professors, like can they call their professors or should they call strangers or is it just like, no, I'm not, no, I know this was going to...
I don't want to invite, any more of those.
Hundreds of people calling you. But I guess my question is a different thing. No, sorry, I got distracted by one of your books. Sorry, I always got distracted by Infinite Jest.
By what?
By Infinite Jest. David Foster Wallace.
Did you read it?
No, we just got it. It looks like a lot of
It's a big book.
Yeah, it looks fun. Sorry. No, I don't. So let me rephrase that. I guess my question is sort of the relationship again between the academic world and scholars and lawyers. They're reading your books, they're reading your law review articles. What is that relationship? Not sort of, can you call for help? That's not really what I was getting
Well,
at.
I hope they're useful. I mean, I guess I think of two audiences, the students and practitioners, and to some extent they have slightly different needs. Try to probably fall between the stools. I try to serve both of them as best I can. I think about accessibility, for example, in the Horn book. I think you have to be able to find the stuff. There's some books it's there, but you can't find it. You have to know the case before you can find it. And I don't know if I'm successful at that, but I try real hard. There's a question of how deep you go into any subject. I sort of feel like, well, if you give simple exposition, then Horn book isn't supposed to be all of your research. That's supposed to be your starting point, not your ending point. And maybe you'd go back to it again and reread some of it or something, I hope, but that wouldn't be the end of your case. So I try to seek balance about how much I say, how much time, how much space I use. That's important. It doesn't. You can't carry a 6-volume work to court. Well, maybe you can if you're in a big firm and you have lots of people carrying 2 each. But most of us can't carry 6 volumes to court. So you kind of like things that are accessible in lots of ways. I think I've kind of wandered away from your central point.
That's okay. No, that's good. Okay, let me ask you some more questions now about writing. And this is, you'll have to forgive me, Jerry. This is a more selfish question because I adore writing.
Will you forgive her, Jerry?
Because I don't know if this will get in this version of the class or not. I don't know how many people are interested in this, but I'm curious in your process of writing, in the sense of, and not sort of the basic dumb, like the very beginning stuff, but sort of, how much rewriting do you do? Do you always work on one chapter at a time? Do you have a lot of things going? Sort of what your process of writing is, and is it different all the time? I mean, is it,
Yeah, it's different all the time. It's, when I was writing the Horn book, I wrote one chapter at a time pretty much. But when you do research for chapter 1, you inevitably find cases that you're going to talk about in chapter 16. And so you don't have to have, but you might want to have some system for dealing with that. That system might be computer's wonderful. I mean, it really allows you a lot of options here that we didn't have.
So how do you, in a large project, how do you keep things organized? Do you, I mean, when you're reading all these cases, are you just saving them to disk, or are you printing them out, or?
Oh, I don't. I try not to print stuff out. People, that's a personal preference. My colleague Ellen Bublick, I think, prints out stuff, and I just don't like to do that. I much prefer to download stuff, read it on the screen. I can highlight it. I can stick comments in. I can put bookmarks in. You can search it so much easier once. If you need to go back and search it, then you can index it. I have an indexing program that's very good. You can index stuff, and so that you can kind of search your own stuff the way you search on Westlaw or Lexis, and that so that helps. That helps organizing quite a bit. But it's no solution. You got to carry a lot of stuff in your head. But I tried to write one chapter at a time, pretty much. But now what I'm working on is a supplement. And I'm reading cases that come as they come down. Case I read today doesn't have a citation. One of those I was telling you about is just out. It doesn't even have a cite yet. It's just a Westlaw case. It goes in 3 or 4 places. Where do you think it goes? Do you want to cite it in all 3 places? Do you want to discuss it in all 3 places? It goes in my horn book. It goes in my case book. It goes in my teacher's manual. Goes into an annual newsletter I get out for people who use my book, torch teachers. And even there, where do you put it? Because there's a lot of choices. What emphasis do you want to give to it? So there are these choices, and so what? You're going to make some wrong choices. Guess what? Somebody else is not going to agree with your choices.
That's the point. You have to decide at some point.
You decide.
Right.
You decide, and you go on with it.
So so you read a case. You're 3 o'clock in the morning. You've had your coffee. You read a new case. Do you start to do you put it in all those different places, or do you?
I try to avoid making extensive notes. I do make some notes sometimes in the case itself. That's the great advantage of downloading. You can kind of facilitate your own note taking. But I try to immediately get it into a position that it's going to be in, rather than make notes and then 6 months later, the old graduate school type of thing where you have the stack of cards and you go back through it 6 months later and you don't remember this. And I just try to go on and deal with it. If it's going to be cited in the chapter on tort and contract, I'm going to go on and stick it in and put the citation there and say whatever I'm going to say about it right then. And if it's also going to be cited in medical malpractice chapter, I'm going to go ahead and do it right then, and then that case is out for now. I don't have to worry about it right now.
What about rewriting? How much rewriting do you?
Well, the actual writing itself, as opposed to research or plugging in cases, is I think I'm such a bad writer. I just keep on and keep on trying to fix things, and I rewrite. Yeah, I sometimes things go very fast, but I write and rewrite, I reorganize and say, why did I put that sentence there? It really goes in the next paragraph. Oh, I don't even need that sentence. And, sometimes you come to this epiphany far too late. It's already in publication.
That is the downfall, right?
But hey, nobody expects you to be perfect. I think people are mostly they're very generous and forgiving, except about commas. People are very unreasonable about commas. I think people are very unreasonable about commas. They insist there's a right way of putting commas, and I've had research assistants over the years who give me this old stuff about you can't begin a sentence with and or but, and I think, how do they still get that? I thought that had gone out at least a generation ago. But, so people are unforgiving about some things, grammar and stuff like that. But I don't think I think they're pretty generous about whether you said it just right or not most of the time.
Do you enjoy writing?
Yeah. It's how I understand stuff. I don't think, this is what I did in law school. I wrote little treatises for junk courses. That's how my outlines were enormous. But that's my way. I mean, people do it differently.
That's your process.
Some people do it without touching pen to paper. I had a student years ago who seldom came to class, never made notes. He read cases, but not very quick. I mean, not very by my lights thoroughly. He kind of, but he somehow knew it all. Isaac Newton underlined, he made notes. This is a genius, you understand. He wasn't in law school, but he was a genius on other things. And he made notes, he underlined, he turned pages down to point to little things. He had so many ways. Some things, some books he was making notes on, he copied verbatim and also summarized and also marked up and also turned the pages down. So when I learned that, I knew I had to quit making fun of students for the way they highlighted stuff. Because everybody does it differently. And if Isaac Newton can do that, then by golly, they can highlight in purple and green and yellow if they want to. And now I do it on the computer. So I think everybody does things differently, and writing is the way that I come to grips with legal materials.
Okay, I have a couple more.
So I do like it.
Good. That's nice to hear, because you do a lot of it. So,
Yeah.
You know. What about non-law? My eye caught that book, so I want to ask you about other books that aren't law. Do you do other reading? Do you think it's important to? Do you think it's important as part of one's life?
Oh, sure. It's important to do something. I was brought up to think reading was the most important thing, but I don't think that now. I think reading is an important thing, and people are different, and we shouldn't be too judgmental. It's like the highlighting. If you highlight in yellow and I highlight in brown, so what? You know, I think I like history a lot. A lot of these books on this shelf, you can't see them, or most of the books on this shelf are history books. And I like history a lot. So that's important to me, but I don't think everybody has to like history. You do, though.
Yeah.
That's your business.
Right. My spouse does postmodern lit, so that.
Yeah,
So,
well, that's infinite jest.
yes.
Yeah.
But-
Yeah. Well, I like a lot of different kinds of books, but my point is, I don't think books are the only thing for everybody. If you read a lot in law practice, maybe what you'd like to do is listen to music or play tennis. I don't think that we should be too judgmental about the different ways people do something, as long as they're doing something. It's the passive non-doer that I think is a problem.
All right, here's another question. Do you ever just get tired of starting at the beginning every year in torts? Do you just think like, I just can't?
No, I don't. You know why? Because it's sort of like trials. You do if you do certain kinds of trial work, there's a certain amount of repetition, and you've seen all this before. You do automobile accidents, or you do, I don't know, workers' comp, or you do domestic relations, all this stuff. There's a certain repetition to it. But what's different is the people. And it's like a kaleidoscope. It's the same combination, but somehow it gets combined differently when you turn the damn thing. And somehow the students in the first year class, yes, they have a lot of the same problems that they had last year, a lot of the same advantages they had last year, a lot of the same viewpoints, but the combination is different. It's the kaleidoscope effect, and the way who interacts with whom and how they interact. It's wonderful. It's just great fun. It's the same thing you like about law practice. It's the clients are different, the witnesses are different. All this stuff that is not about book stuff is always got this kaleidoscope effect. So it's exciting.
Mm-hmm. Okay, I'm going to ask one question. You don't have, but this is a new question. I met with Dean Massaro today, and so I'm not as comfortable with this question, so you don't.
That's okay. I know how not to answer a question. I just talk till the tape runs out.
She wanted me to know. She wanted me to ask about spiritualism and how the connection of like the way you practice law or the way you teach and your own personal. And you don't have to be. I've never asked this question to people yet, so you're my guinea pig.
Okay, go ahead.
So I'm not sure.
Spiritualism.
And that I guess means a lot of different things. Some people it's very religion, and some of it's just sort of their own personal philosophy, I guess. I'm not sure exactly what spiritualism means to people, and I don't know if it's too personal.
I guess the word is a put off to me.
Yeah.
I don't think the connotation that word has to me doesn't have much to do with anything. I guess, and that, I think of think of Yeats. You ever read any Yeats? You know, he got all involved with these spiritualists, and they would pull these seances and stuff. Well, I don't think that's what she means. But what do you mean? I was reared in the Baptist church, and I talked a lot about the spirit, but I don't think I much connect what I heard in the Baptist church with anything that is central to my life.
Right.
So I have trouble with this, yeah.
Yeah.
Yours seems like philosophy too.
Like philosophy,
yeah, as opposed to.
Well,
I knew I was going to
I
mess
don't
this
know.
question up, so.
I think,
That's why you were
there's if what you mean, if you take it in the broadest sense, I suppose what you'd have to mean is something besides tangible goods in life. I mean, if that's what you mean, well, sure, music, books, paintings, all of this is a big part of life. Love, human relationships, of course. What else can you say? But I don't see that it's what you would say to anybody in any profession. It has nothing to do with what profession you're in. It has to do with whether you're a human being. And if you are, and not everybody is, believe me, you'll see if you practice law, you're going to care about other people. You're going to care, maybe you're not going to care about paintings because that's a matter of personal taste. Maybe you'd rather go to a rock concert, but you're going to care about something that isn't tangible goods in life. So if that's what you mean by spiritualism, you bet.
Let me try it again. Let me see, because it's better to practice on you than someone else. What about what moves you, like that isn't about the law? I mean, that same thing as music and books and sort of, I don't know. I mean, I think that we're trying to get to something that's not material and not analytic and not career driven.
Oh,
that
people,
sort of
people,
that quiet space.
people. It's about people. It's about people. I like paintings very well, but if you had to rank things on a hierarchy, it would be people. What would be the way I'd like to spend the evening? Every evening is sitting on the porch in a rocking chair with 4 or 5 friends chatting. I spent evenings like that. Yeah, at Jerry's house. Well, maybe not sitting in a rocking chair, but with friends and elsewhere. And I don't do very much of that. It's something that I don't get enough of. But it's my own fault. I mean, it's not anybody else's fault. But it's it's one of the nice things about law practice is that you might get a belly full. You deal with people all the time.
Okay, can I ask you 2 more questions? We're running over a little bit.
Take all you want.
Balancing life and practice.
Well, I've just confessed I'm not very good at balancing life and teaching.
Uh-huh.
So I don't know if I could give anybody any advice about it except to do better than I do. Which unfortunately means working less. And
Do you ever get in trouble? Do you ever get upset that he works too much, or I mean, it's that sort of thing of sort of how do you keep the relationship, your life, your relationships, the people that you love.
Well, I don't work more than 12 hours a day. Well, maybe 15. That leaves lots.
Mm-hmm.
That leaves lots. If leaves several hours a day, and if you take off on weekends, it leaves an incredible amount of time on weekends. So. You don't have to talk about doing without personal relationships, and you shouldn't talk about that. Or even animal relationships, in spite of all my jokes, I do have a cat. Don't publish that.
We'll edit that out.
Edit that out.
Well, that's good. And were you always that way? Because I mean, you hear about people who just completely ignore their families and their pets.
No, I don't think the Edison type of myth is a very good model for anybody. But on the other hand, I will say work is rewarding. If you like your work, it is not without its own, if you like, spiritual rewards. It's not about money. It's not about any tangible benefit. It's not about seeing a book in a hardcover. It's about the work itself. So I don't want to downgrade the work part. That is important. You know what Faulkner said about work, right?
No, I don't. Tell me.
Well, it was something like this. You can't drink 8 hours a day. You mean alcohol. You can't make love 8 hours a day. What can you do all day long? You can work. Work is what you can do all day long, and you can do it all year long. And there's a kind of wisdom in that, I think, in that what he's saying, at least what I take him to be saying, is that work has rewards, that we shouldn't just see it as slogging through. If it's something you like, which, Lord, I hope it is something people like if they go into practice of law. I hope they're not doing it for any reason other than, yes, it is rewarding to them. It is good. There's bad stuff in it, but it is overwhelmingly good stuff. But it's not like work. You ever read Upton Sinclair? These poor old workers working away in the, shoveling stuff in the slaughterhouse or whatever. And it's just drudgery all day long. They get too tired to eat when they get home. We're not like that. We're not dealing with that. We're dealing with work that is, got some rewards to it. So I don't want to minimize that when you talk about balance.
All right, here's I'm going to ask you a negative question and then a positive question to end. Do you ever, from my point of view, you've described a fabulous life. The writing and all that.
Couldn't
That's
be
my, but is there ever a time in your life, months or years or days where it wasn't what that it was just icky? That, the notion that,
Everything gets old.
Yeah.
Yeah, you when you don't do anything but one thing, it gets old. Now, I think that would be true no matter what you did. It would get old if you did nothing else. So that's another reason for some balance. But no, I think I get tired sometimes, and I say I really need a vacation. And but that takes care of it. After 2 weeks in Italy, I'm ready to go again.
And you have to do two. We end with this dorky question, which we just have. You have to answer this one because we got everybody else doing it.
All right. Okay.
And you have to do it twice because you practice and you taught, or you teach. What is one of your happiest or happy moments in your life as a lawyer and your life as a professor or as a scholar? What is what when you think about like a happy moment? What would that be? And it's been different for everyone. Runs the gamut. How that's interpreted.
Well, I don't know. I probably would change my answer, on reflection. But one that occurs to me in practice was a guy came to me who had been fired. He worked for the city, and he had a kind of paranoid story that he said essentially that he was fired because he had seen commissioners requiring some of the people in his department to pave the commissioner's driveway or something like that. I don't remember exactly what it was, something on that order. And I was kind of, this sounded like this pretty much fiction stuff to me. But I felt like, he was entitled to something. He didn't have any money. He just lost his job. He was a working man, like $40 a week or something in the 50s. And so I said, well, you come talk to me every day after work, after my work. You come talk to me at 5, and I'll go through this with you and see what we can find out. And the more I investigated, the more I thought it was true, and I began to get into it more and more, and we finally took some depositions and claimed a civil service claim, and we took some depositions. It was all very low-level stuff. There was no money. No money for me. He had no money. We didn't have any cost. We didn't have anything. But we just kind of did it. It was my time, and we did it. And I got his job back with a raise. And they didn't want this stuff out. And they thought, finally, we'll shut him up by hiring him back. And they did. And so I was very, very happy about that. That was very pleasing to me. I liked that a lot. It was very different. Most of my other work was representing insurance companies, and I liked that too. But this was kind of nice. This was a nice moment. Bill got his job back, and that was a happy moment in practice of law. Happy moment in teaching. Well, they're all kind of happy in teaching, and you kind of enjoy it all. I enjoy the almost all classes. Every once in a while, there's a shark in the class that makes it hard for everybody, but that's very rare. I don't know if I can think of a particular moment. What did other people say? Give me a hint.
Jerry, what did other people say? I don't
You're
know.
the first professor that I've been
Oh, that's right. 'Cause
doing
you were,
for, so.
yeah. I don't know.
Okay, well, that's the
That's
best I
good
can do, sorry.
Most of them, yeah. I don't think we actually have asked about the teaching part. We'll ask more people.
Huh?
I don't think we have asked the teaching part. Now that I think about it, I think we've only asked about
Professors.
practice.
Yeah, practice.
Yeah.
Okay, well,
Yeah,
then I've
so-
done my share.
But that's good. I mean, it's pretty good. Happy all the time. You know, that it's a generally happy
Well,
job. You know?
I think it's a very satisfying life in many ways. Both law practice and teaching have their limits. I thought when I went into teaching, it would be all intellectual conversation all the time with my colleagues, and that has been everywhere I've been in a lot of schools, and everywhere I've been, it's always been the same. That's the rare and unusual event. And I'm not much one for institutionalizing that. I kind of like doing it in the coffee room, so I don't go to some of the institutionalized set pieces that people have. Maybe I'd be happy if I did, but that's been a disappointment compared to practice, where my father and my other partner and I every week talked about all the week's cases that came down from the Supreme Court. We'd sit down and talk about them, and every Saturday morning we'd go through all the cases on our own docket. What do we have pending and what's the status? And those were very good discussions for me. I really enjoyed those. They were helpful. They were frequently intellectual. They were frequently problem solving, sometimes speculative when we talked about Supreme Court cases. And I think in some ways teaching has been a little disappointing to me in that kind of thing. I like my colleagues, and as far as I know, they like me okay, but I don't think that we have enough of that. We go to the lunchroom, people are talking personalities or baseball. It's like going to get a haircut, you know.
Do you think that's because so many people are doing so many specialized
I don't know.
things?
You know, the only time I ever was in an English college at table, the people, you know how they set up. They in the college they'll have a historian, and they'll have a modern language, and they'll have a romance language teacher, and they'll have that philosopher and psychologist. So all these people are different. They're all different. I mean, that's the whole point, is that they're different, and they share quite well. They talk. They're interested in what each other might be doing, if for no other reason than to find a way to put them down, because that's the English style, is putting people down. And so they want to know what other people are doing so they can make a witty comment. So at least you got that interchange.
Yeah.
Do you find you're getting that, like, though, on the internet, if you go on the different threads about different topics, that it's, it's...
I haven't done much of that, but the ones that I've received on my listserv are, I'm old, that's the problem, is it's all reinventing the wheel to me. I mean, I've been around this track a long time, and you know, when people start talking about, do you teach in depth or you teach in breadth, I think, oh no, I'm not going to read this because it's an unanswerable question in the first place, and in the second place, I've been through it many times.
How about the access to the internet, just as far as like getting up at 3 o'clock in the morning, and you can download things then, and has that been much easier, or is it, do you use that, or?
I don't use the internet. I use a modem for Westlaw. I do use the
Okay.
internet, but
Right.
not for the
Westlaw.
cases. I use the Westlaw. That's
You have access to that 24 hours a day.
24 hours a day, and it's a different world, and students don't have any idea what a slogging misery it was before the computer,
Right.
where you had to look at maybe as many as 20 digest books to get through a 10-year period, and then you went to the preceding 10-year period, and it was just impossible. And indexes weren't any good. You couldn't do search words the way you do on Westlaw. Nobody can imagine how bad it was unless they lived through it.
Right.
So it's wonderful, truly. She wanted to find something positive to end on.
No.
Yeah,
Okay,
anything else?
are we through?
We're through.
Bye.
Bye.